Hello, everyone, and welcome back to McAfee Taft's continuing coverage of the legal landscape and human resource implications of the 2020 COVID-19 and coronavirus crisis. My name is Paul Ross, and with me today are my colleagues, Natalie, Ramsey, and Josh Solberg, two other shareholders here at McAfee Taft. And this video is being recorded on the afternoon of Monday, March the 30th. We're here today to update for you the legal happenings that have occurred over the last week or so since our last video. I want to take this opportunity to remind you of the McAfee Taft COVID-19 Resource Center located on our website. We've been publishing additional alerts and information all week long. There's probably more information there than any person could take care of in one day, but please make sure to take a look at that information, and we'll keep you updated on changes as they come out as the crisis continues to evolve. Today, we're going to talk about two specific happenings over the last week. First and most recently, we learned about the CARES Act, the financial stimulus bill, and some opportunities for employers to gain payroll protection loans that are potentially game changers as we respond to this crisis and handle all of the challenges that we have as employers in Oklahoma. And then second, we learned quite a bit about our obligations under the FFCRA. The Department of Labor published 3 different supplemental materials over the week, providing us detailed answers about some of our obligations, and we want to share some commentary with you about that today. So let's start right there and get into this just as quickly as we can. We have a lot to cover. Josh, it seems like the biggest news of the week is the fact that the CARES Act has created payroll protection loans that are in some ways forgivable to employers. What do we need to know about that?
Yeah, Paul. So from a high level, the payroll protection loans allow eligible borrowers who are generally businesses that are both for-profit and nonprofit and other entities who generally have 500 or less employees to obtain loans that have very favorable terms for those employers. They can obtain loans for up to the lesser of 2.5 times their average monthly payroll cost for the prior year, or $10 million. And the loans can only be used for certain things, specifically and primarily employee-related expenses, interest payments, mortgages, things like that. They are subject to typical small business association loans, with the exception that there is no personal guarantee and there's no personal recourse against the principals except in cases of misuse. And then, as you noted, the biggest key element to these is that they are subject in most instances to almost entire forgiveness of large portions of the loan. And then there's also some favorable allowances for deferral payments and things like that.
So I know all of us have been speaking to clients about these programs from the moment they were announced over Thursday and Friday of last week. Natalie, the main thing I think we've been hearing from clients is that they're most interested in this idea of forgiveness. So what does a small employer that's eligible for one of these payroll protection loans have to do to make sure that that loan ultimately is going to be forgivable?
So, Paul, there are some conditions on maintaining that forgivable status. First and foremost, we're looking at expenses that are incurred from the time the loan is taken out, looking forward for 8 weeks. And so you can get things, the forgivable amounts will include payroll expenses for employees who earn less than $100,000. You can have forgiveness of interest on existing mortgage loans as long as those mortgage loans were in effect or in place before February 15th of this year. Rent and utilities, again, if those rental agreements and utility arrangements were in place before February 15th of this year, they're subject to forgiveness. If your payroll if your workforce has a reduction in compensation level below 25%, there'll be a proportionate reduction of loan forgiveness. Another really key and important part of the forgiveness framework here is that you have to maintain your staffing levels. And so if there is a reduction in your staffing level, there'll be a proportionate reduction in forgiveness based on the staffing levels as compared to last year, or a time frame from January 1st of this year to February 29th.
So essentially the idea is that an employer who maintains its workforce and maintains its payroll over this period of time is going to be eligible for at least some or maybe all forgiveness of the entire loan that they've incurred. And I understand the motivation for that type of provision to be in the stimulus bill, and it sounds like a good opportunity for employers to respond to this crisis. So what is the situation for employers who have already had to take an action prior to now? I know all of us have dealt with and helped employers try to get through the really hard part of this crisis, which is that a lot of small businesses had to react way before we knew what might be in the stimulus bill. So what does the CARES Act or the stimulus bill say about employers who already had to lay off workers or already went through furloughs?
So those employers that have already had staff reductions prior to the enactment of the CARES Act will have an opportunity to rehire those individuals and not suffer any penalty. They've got essentially a 30-day period from the time the CARES Act takes effect, which is effectively June 30th. So if those employees are rehired and their staffing levels are restored, then their loan forgiveness will not be reduced at all.
Great. So Josh, what about other types of loans? I understand there's at least 3 types of loans available under the CARES Act. What else is available besides the payroll protection?
So the other 2 that are available, the first is the economic disaster loan. And just at a high level, it allows eligible borrowers who have suffered substantial economic loss because of COVID to obtain loan amounts that are generally up to about $500,000. You are required to use this loan for working capital needs and things of that nature. And so again, there's limitations on what you can use those dollars for. The second type is the emergency relief loan, and that is available for businesses that have sustained similar substantial damage, but also have not been able to access capital or loans. And in those instances where their business is jeopardized, the continuation of their operations are jeopardized, they can also seek loans. And for that particular loan, there's also, similar to the paycheck loan, a requirement that employment not be reduced below a certain level, specifically 10% below where it was operating previously.
Okay, Josh, so what do we know about implementation dates at this point? The stimulus bill is out, but when does it become applicable? When can we start applying for loans, et cetera?
Yeah, so lenders can immediately begin applying to the SBA for a guarantee of eligible loans, and clients who are interested in obtaining those loans should start getting with their counsel and start applying for those loans as soon as possible. For the emergency relief and the economic disaster loans, those funds can be immediately available within 30 days once an application is made. So again, for clients who are in need of those loans, they should get with their lenders and begin applying for those as soon as they can.
So Natalie, as we look through the CARES Act and try to understand a little bit better what the provisions are and what the details might be and maybe what strings might be attached to these loans, are there anything that we found so far at this stage that employers need to be aware of before they try to take advantage of these loans, as lucrative as they may be?
Paul, employers are going to have to make a good faith certification that they're going to comply with certain requirements of the CARES Act. Most notably here is that they're going to be maintaining union neutrality. And what that ultimately is going to mean, we'll probably figure out through NLRB decisions in the courts in the future. But there are 2 components to this, and one is that employers are going to remain neutral to union organization. Unions will likely take the position that that means silence on the part of employers in the face of organization. Employers historically have had free speech rights to share facts and information about the drawbacks of unionization if they choose to. So we may find that there'll be some level of dispute about how much information can be shared. The Taft-Hartley Act does have a free speech right component laid out in it. And so, as I said, I think we may find that there's some litigation that ensues, but employers are going to need to proceed very cautiously if they find unionization efforts growing in their workforces, because these requirements for neutrality will be in effect for the entire balance of the loan. So we know you're going to have questions about these different loan programs. Obviously, we're learning as we go here, and there are a number of details to cover that we're going to spend a lot of time getting into over the next several days and weeks. But reach out when you're ready to start talking about which one of these programs is best for you. Natalie, Josh, I would be happy to get you in touch with one of our banking or business lawyers
that'll be happy to share with you the ins and outs of this program and try to determine the best route for you and your company going forward. So let's move on now at this point to talk about the second issue that we wanted to update you on, which was a very, very busy week from the DOL's perspective regarding the new obligations under the FFCRA, the Families First Coronavirus Response Act. We've talked to you a lot about that in our previous videos, both before we knew for sure the law would be in place and immediately after it had been published. But there have been a number of questions about that particular statute that we just did not know the answer to. We had been giving you what our best analysis was of those questions and trying to anticipate what we thought the DOL, what position the DOL might take about those questions. But over the last week, we've gotten a lot more information and some specific answers finally from the DOL. So before we get into at least some of those questions, and we don't have time to address them all today in the video, but before we get into those, just a quick reminder about what the FFCRA is. So that law essentially requires small businesses or businesses with 500 employees or fewer to provide two benefits to its employees related to the COVID crisis. One is 80 hours of paid sick leave for one of 6 very specific COVID-related reasons. And we've talked at length about what those are in previous videos. And then second is an extension of the FMLA that will provide benefits in one very specific circumstance, which is essentially the closure of a school and the need for an employee to be home to care for a minor child who would otherwise be in school or in daycare. And so that's the essential overarching theme of the FFCRA. But we'll talk now about some of the specific questions that we've been able to answer over the past week. And Josh, I'll go back to you. I think the first and kind of most prominent question that was answered by the DOL this week was an effective date of the act. We had some lack of clarity and we were guessing that it might be April 2nd, but we've now learned something different. So what did the DOL have to say about that?
So the DOL said that the effective date is April 1st. And what that means is 2 things. Number one, if you have paid tax or paid leave to individuals before April 1st and are intending to seek a tax credit, you will not likely be able to do that. Secondly, it means that if you have provided benefits before April 1st in terms of paid leave to individuals, you're going to have to provide them again after April 1st. The Department of Labor has also issued some enforcement guidance that says that they will not actively enforce the new law until April 17th for employers who do not commit willful violations if employers are acting reasonably and in good faith. And what that means is they fix the problem when they identify it, they are not acting willfully, and they agree to comply with the law on a go-forward basis.
So this video will be coming out Tuesday morning, March the 31st. That essentially means if you're watching today for the first time and you haven't had an opportunity to think about this before now, it's time to act. And so again, please reach out and make sure if you've got questions or you need help implementing this process, your employees who have emergency issues that come up from now forward are potentially at least going to be entitled to both of these kinds of leave. So certainly give some thought to that and reach out to your McAfee and Taft attorney about that. Natalie, I mentioned at the beginning that we're talking about employers with 500 employees or fewer. The DOL has given us at least a little bit of guidance on how we go about counting employees and determining who has 500 employers and who doesn't. I don't know that they've given us a complete answer yet, but what have they told us at this point that we can be helpful in passing along to clients?
It's been a very important question and one lots of employers are trying to self-analyze on. That 500 employee count is going to include temporary employees, part-time employees, full-time employees. That's going to be temporary employees, whether they're employed by a temporary agency. If they're working on your premises, arguably they're going to go into your 500 count. The other things we're encouraging people to be mindful of is if we're working to come to try to exceed that number of 500, remember that, you know, the analysis of the application of the FMLA, if you're an employer that's closed in other circumstances, that the FMLA is still going to apply to you. And so you want to be careful about the way that you're trying to push your numbers one way or the other. And as we discussed earlier, we're still learning a lot about these loans, but employers with fewer than 500 employees are potentially going to be available for some payroll protection loans going forward.
Yeah, so essentially, tough question for employers. Do you want to try to argue that you have more than 500 employees so that you don't have to provide these benefits? But if you do make that argument, then maybe you're subject to the FMLA and integrated enterprise test going forward on a long-term basis, and you're not eligible for a payroll protection loan.
That's right.
So a lot to be analyzed there, a lot of thought process to go into that discussion. But let's talk about the other side of that now, Josh. There is a provision in the FFCRA that talks about an exception, a potential exception, for employers with 50 employees or fewer. So what kind of guidance did the DOL give us on that? When does that apply? And is it likely to be something we're going to be seeing the DOL hand out?
Yeah, so the Department of Labor has said that for small businesses, 50 or less, they need to begin to document the reasons why they may qualify for an exemption. Specifically, they need to show substantial economic harm caused by complying. And things that would include that would be if their expenses are going to exceed their revenue, if they are not going to have enough employees to perform the job functions, or if there's going to be some kind of additional harm caused by having the employees be there instead of being out on a paid leave.
So if we're going to talk about kind of employers' expenses and kind of analyzing what's going forward under the FFCRA, it probably is a good point to ask this. I mean, what kind of amounts can employees actually get for this paid leave? So I understand that there are some limits in how much of that, how much pay they actually receive under a paid sick leave analysis or under the portion of the FMLA that's paid leave. So what are the limits to that? What do employees get when they use this leave?
Sure. Anytime they use the emergency paid leave, they can get the greater of their regular rate of pay, federal minimum wage, or the applicable state minimum wage, up to a maximum of $511 per day or $5,110 over the totality of their leave period. For paid family leave, which is for school closures only, employees can expect to receive 2/3 of their pay up to a maximum of $200 per day or $12,000 over the entirety of their leave period.
Okay, so Natalie, a moment ago, Josh mentioned something that I think is really important, and I want to go back and emphasize that point because the DOL went out of its way to address this a couple of different times in their various publications over the last week. But I think it's important. We just heard Josh talk about the limits of what an employee can receive each day for paid leave, and those limits are important because employers need to understand the limit of their available tax credit. They're only going to be able to get a tax credit back for the limits that Josh just told us about. And so the next question would be, do employers need to be careful about the leave that they have already given? And as I mentioned, or as Josh mentioned a moment ago, there has been some discussion about this. And so if employers have given leave before April 1st, are they going to be able to get that tax credit?
Unfortunately, the answer to that question is likely no. Those banks are going to reset on April 1. So if you've afforded leave to an employee, paid leave prior to, and whether it's sick leave or vacation or PTO, prior to April 1 effective date, then those employees are going to rebank with 80 hours, and those emergency hours can be used in advance of any other hours. And any of those hours that have been paid up till April 1 will, again, likely not be subject to the tax credits. The DOL has made pretty clear that they're going to start fresh with an April 1 date and move forward, and they're going to expect employers to provide those banks anew on that date.
So, Josh, kind of going back a little bit and answering another question that we weren't necessarily very clear about until the DOL regulations came out, but there's a lot of discussion amongst employers about the idea that this new FMLA leave doesn't contain all of the qualifications that employees would normally have to go through. You don't have to have been employed for a year. You don't have to have worked 1,250 hours. There's no mileage requirement. All of the things that we're used to talking about for FMLA leave don't apply now, and it appears there's only a requirement that you've worked there for 30 days. So what's the what's the analysis of that, and how does it apply in the sick leave process too?
Sure. So there are two elements to the new law. The first is the emergency sick leave portion. If an employee has been employed there for 1 day, they are immediately eligible for emergency sick leave under the law. For the extended FMLA leave, in the instance of school closures or daycare closures, an employee must be employed for 30 days, 30 calendar days before their leave would begin to be eligible.
Okay. And so while we're talking about leave and while we're talking about what's different and what's the same in ordinary FMLA leave, what about the concept of intermittent leave? So we've had this discussion about some provisions of the FMLA, traditional FMLA will still apply, some won't. We weren't really clear in particular about how intermittent leave was going to apply. What do we know now?
So the Department of Labor has said that intermittent leave can be provided to employees if the employer agrees, but it does not have to be. And so in most instances, unless the employer agrees otherwise, there will not be intermittent leave. And what that means is the individual can start their leave when the need for it arises, and they must take that leave in a continual block until either their allotment that they're entitled to has exhausted, or the condition that required them to take the leave has gone away, so they're better and can return to work. However, the Department of Labor has encouraged employers to work with employees and to be creative in their arrangements, and have encouraged employers to consider intermittent leave if they would like to, but they do not have to at this time.
So maybe at worst, it's efforts or it's evidence of an employer's good faith intention to provide the kinds of benefits that the DOL intended, or that the Congress intended, even if we're not necessarily required to provide them.
Exactly.
Yeah. Natalie, let's go back and talk some more about the employers that have already made kind of the hard decisions and have had to terminate employees or furlough employees prior to the effective date of the statute that we're talking about now. We've had employers ask this question a lot. I know you've dealt with it personally, but what about the employees who were subject to termination or furlough before April 1st? Are they going to be entitled to these benefits going forward? Did the DOL give us some guidance on that?
The DOL did give us some guidance on that, and the short answer to that question is no. Employees who were laid off before April 1st or furloughed before April 1st, which means essentially that they haven't been scheduled to work, so there's no expectations that they're going to come in and work on a regular basis, are not going to be entitled to either the emergency sick leave or the expanded family medical leave as long as they remain in a laid off or furloughed status.
So what about the idea of record keeping related to this? So we've talked about who's entitled to leave, who's not entitled to leave, when are their tax credits, when are they not. What are employers going to have to do to keep track of what they have done? Do we know at this point what's going to be expected of them in order to establish the fact that they've been in compliance?
The DOL they've provided some level of guidance, and they've sort of backed it up a bit just in the last couple of days. What we know is that there will be the need for there to be substantiation on the part of the employer in order to be eligible for that tax credit. And it also can be required in order to afford an employee leave. The specifics about what it is that will be required are not absolutely clear at this point. What they tell us is that we're going to be looking to the IRS for guidance, and we believe there'll be some regulations issued from the IRS that will give us some more clarity about specifically what we should be getting from our employees. We do know from the DOL's current guidance that if you're going to be off in connection with displacement for a minor child due to a school closure or a daycare closure, that you can look to things like news releases, orders from the school, emails from child care providers that indicate that there's a closure. And you want to keep those in your files, especially when you're going to be applying for those tax credits looking down the road.
Yeah, so interesting thoughts about the requirements for what employees are going to have to show to substantiate their need for leave. I had an interesting question come up today, and I'd be curious what either of your thoughts are on this. So I had an employer call me and ask me today whether they should consider waiving the ordinary certification requirements under the FMLA for an employee who says they have a serious health condition that makes COVID more likely dangerous to them, and they would like to have regular FMLA leave under a serious health condition qualification, but their doctor was refusing to spend time to look through the certification requirements and fill out the certification requirements. And the employer asked me, should we just waive that requirement? And I think ordinarily I would tell an employer no. I think I would tell them that you would want that serious health condition to be substantiated. But in this case, particularly considering this guidance, that it might be a good idea to actually make an exception to that. I don't know what your thoughts are, if either of you have any thoughts on that.
I think subject to the employer's intent to try and get some kind of tax relief, I would normally say I totally agree with relieving the requirement, because in this circumstance, healthcare workers are overrun. They're not going to have time to get that information to employers and things like that. But if the employer is intending on seeking tax relief, it would be in the employer's best interest to have some documentation. Maybe not the formal FMLA form, maybe not the exact I being dotted and T being crossed the way we normally would, but let's have something so that we can seek some tax relief and help the employer out.
Go ahead, Natalie.
And just to follow up on what Josh says, I think that what we have to recognize is that we're going to have some level of flexibility here, because we're dealing with an overrun. The medical industry is overrun right now. And so we may wind up having the certification we need in our file that we ultimately utilize to get the tax credit. It just may not be in the time frame that our employers and human resources professionals are used to.
Right. I think that's great advice. And I think that kind of leads me into the next question that the DOL addressed. And I think that's a good segue. I mean, we have a situation here where things are outside of normal. We have people experiencing emergencies and circumstances that are beyond what we would ordinarily be prepared for, and they're certainly outside of the norm. And so one of the things that has come up as a question is, does this unique circumstance, does this unique new law provide employees who are eligible for this new FMLA leave, are they entitled to 12 more weeks of leave to address this unique problem? Or are they entitled to just a total of 12 weeks that can be spread across all the potential needs for leave, like would traditionally be the leave? What did the DOL have to say about that?
So the DOL has made it clear that FMLA leave, whether it's the emergency FMLA leave that we're going to talk about for the care of minors that have been displaced because of a school closure or a daycare closure, or FMLA in its traditional format, if you're an eligible employer under the Act as it existed prior to these new amendments, is 12 weeks in total. It's not 12 plus the 10 or plus the 12 that were associated under this Act. It is 12 weeks in total. The sick leave component does not, it's irrelevant whether or not you've already exhausted your 12 weeks of leave. So if you've exhausted your 12 weeks of FMLA leave prior to April 1, you can still be entitled to the sick leave component and the 2 weeks of paid leave there, but you won't be entitled to any additional FMLA leave if those balances have already been exhausted in the year as run by your employer.
Okay. So obviously a lot of questions. We've addressed some of them at this point. There are a number of others that the DOL has addressed and a number more that they still have not addressed that we're still hoping for some guidance on. Josh, what happens if we mess this up? What happens if an employer in good faith does the best that they can, but an employee feels like they're being denied some either paid sick leave or paid FMLA time that they think they're otherwise entitled to under the FFCRA?
Sure. And I think what I would say is, first, if you are an employee, and if we're talking to you as an employee, I would tell you to talk to your employer. See if you can work it out. Times are very tough and challenging, and there's a lot of moving pieces. And a lot of times simply asking the question to your employer will get you at least an answer. You may not like it, but it can get you the answer and sometimes even the relief that you want. Short of that, employees have the right to go to the Department of Labor. The Department of Labor has the right to investigate and remedy any wrongs. And then individuals can also go get a lawyer and file a lawsuit under the Family Medical Leave Act, in which case they'd be entitled to remedies that would include back pay if they were to lose their job, time that they should have gotten paid for sick leave, potentially reinstatement, liquidated damages, and attorney's fees.
So how does this particular act deal with some of the things that we're used to hearing in the arena of the FMLA, such as interference claims or FMLA retaliation claims. Are those things still going to be applicable, still a part of what we're dealing with under the new provisions of the law?
Absolutely. So generally speaking, employers are prohibited both from interfering and retaliating against an employee for their FMLA rights. So we cannot keep them. You cannot interfere with taking rights that they are entitled to. And if you attempt to interfere with that, you could be subjecting yourself to liability. And that is strict liability if you are found to have interfered with an individual's rights. You will lose and you will owe money. Additionally, you cannot retaliate. So if somebody takes the leave and then you treat them differently, negatively, and you harm them because of their exercising their rights under the new law, you will be subject to liability as well.
That brings us to a close as far as what we wanted to discuss with you today regarding the Department of Labor's communication to us over the last week. And we do expect certain formal communication from the Department of Labor this week in the form of actual regulations enforcing the FFCRA. So we'll certainly receive some more detail later this week, and we'll be in touch with you again to discuss that as soon as we've had the opportunity to review it and digest those regulations and communicate to you the more detailed information that we should get out of formal regulations that will be better than just a simple frequently asked questions website. But in the meantime, if you want to discuss the FAQ or any of the particular topics in the FAQ that we didn't discuss today, please give us a call. Be happy to discuss that with you. And we'll continue to look for other opportunities to bring to you information about the crisis as it unfolds. We appreciate your time and attention as always, and we will certainly be in touch.